Hi, good morning, guys. So you had some questions about getting laid off on H-1B, and we decided that we'll just do a call for the whole community. Thank you for participating in that. Why don't one of you take lead and start asking your questions? Go ahead, please.
Sure. So my first question is, there are two different dates that I got from the company saying that I have been laid off. That my date of termination, my last working day is November 4th, and my separation date is Jan 4th. So I wanted to know when the grace period of 60 days for H-1B visa will start.
Okay. So first of all, let's take a step back. And before I answer your question, which date to consider, let me go into how does the 60-day grace period work. So if somebody is on H-1B and they suffer a termination of the employment, they will not always have 60 days. They can have less than 60 days if their status I-94 is expiring before 60 days. So for example, if your H-1B approval was till or is till October 1st, you won't have 60-day grace period. You will only have up until October 1st. The law is you have 60 days or the time remaining on your H-1B, whichever is lesser. Make sense?
Got it.
Okay, that's number one. Number two, now they have given you strangely two dates. One is the date you are stopping work, and the second is the official termination or the official separation date, correct?
Correct.
Okay. Now, when does the 60-day period begin to run? That's a difficult question to answer. If they are going to keep paying your salary all the way till the end of the actual separation date, it can be argued that the 60 days should begin following that date. Okay. Would that argument be successful? I do not know. What would be the most conservative and safest thing to do? I would say it would be to consider the date you stop working as the period following which your 60-day grace period begins. But that's a very conservative way to look at it. Because if you're getting paid all the way to the end of your actual separation, I think it can be reasonably argued that I am in status until I'm actually not getting paid. Because think about it this way. What if I'm on bench? What if I'm in between projects, but I'm getting my full salary? I'm considered to be in status. How is this any different from getting benched? I'm getting full salary. So if you are getting full salary, in a pinch, we can argue that you are maintaining status until the actual separation, following which you should have 60 days. Now, as a practical matter, what I can advise is whenever you file an H-1B, if you are considering the more aggressive option, which is my H-1B 60-day grace period begins after my separation date, just make sure you file your case premium processing. It is important to remember, if a premium processing case is filed, the fees can be paid, the premium processing fees can be paid by the employee if the premium processing is requested by the employee for their own benefit and not by the employer for theirs. So you could even offer to pay the premium processing fee for the following H-1B. Does this make sense? All of this is clear?
Got it. So, how much will be premium processing fee generally?
Oh, beats the heck out of me. I think it's $2,500. I don't remember the fees. You can just Google it, H-1B premium processing fees.
Got it. Okay. I
Okay.
see.
So I believe it's $2,500. What
Mhm.
was your next question? Go ahead, please.
Yeah, so in case I get a new employment, considering the 60-day period that you told that it might already have started, considering that edge case. So I have this plan of going to India in the month of January. Uh, So I have two questions here. I wanted to ask if I am permitted to travel outside US during the 60-day period, and if I need a new H-1B with everything stamped for the new employer, or I can travel with my old H-1B.
Okay, so the question is, during this 60-day grace period, can I travel and can I return using the old employer's visa? And the answer is, you should not travel unless you have already filed and USCIS has received your H-1B petition for the next employer. If the next employer's H-1B is approved, you can then travel using the same visa which you had for your old company. So my advice would be, do not travel during those 60 days. And once you get the approval and you get change of status, you can then travel using the new employer's approval and the old employer's visa. Okay?
Got it. Um, my next question is, in case I don't find another employment within the 2 months grace period, so when is it likely for me to apply for H4? Since I have plans of getting married, and so I have multiple questions there to start with. When will be the right time for H4 transfer
Okay.
for me to file?
So let's parse that for a moment. There are two options: people like you who are about to get married, or people who are already married to somebody who holds another status like H1 or F1 student status. They can convert to a derivative status, or they can even apply or try to get tourist status, visitor status.
Mm-hmm.
Changing to another status requires that your application for the change of status must be received by the USCIS, received within that 60-day grace period. Okay. Now, as a practical matter, because it takes a very long time for the government to decide the derivative applications, several months, even if you are still looking for a job during those 60 days period, it is not exactly unsafe for you to apply for a derivative status, say on the 40th day or 50th day. But you can apply anytime during those 60 days, as long as your application is received by the USCIS within those 60 days. Okay. Now, here is an interesting problem. Let's say that 60 days have passed. Your application for H4, F2, L2, or even B1, B2 tourist status is pending. As long as the application is pending, you are still considered to be maintaining authorized stay in the United States. That means you are legal to stay while the application is pending. But what if you find another job? Application is pending, 60 days are gone. Can you convert to H-1B transfer within the United States? The answer is no. What the government will do is, they'll say, well, you have an application or a petition pending, an L2 or an F2 or an H4 or a B1, B2, but that is not considered to be full status. So therefore, we'll approve the H-1B, but you have to go outside USA and get a visa stamp if you don't have one, or come back using that visa and the new approval, H-1B approval, to activate your H-1B status. So in other words, they will not give you H-1B status within the United States if your petition for conversion or change of status is pending. Does this make sense?
Yeah. Yeah. I see.
But once it is approved, then let's say you converted to F2 or H4 or L2 or B1, B2, and then you got an H-1B job offer, you applied, you will be able to get change of status within the United States, but you cannot start working until the H-1B is actually approved. Normally, if you apply, this is an important rule to remember. If you apply for an H-1B within the 60-day grace period, you can start working as soon as the USCIS receives your application.
Right.
You don't have to wait for the approval. But when you have converted to a derivative status or a tourist status, you cannot start working until the H-1B is actually approved. So that is one difference in filing within the 60 days and after the 60 days. Okay.
Got it.
So, sorry. Yeah. So, Rajiv, just another question. Since we are planning to travel anyway in the month of Jan, do you think it's safe? Do you think it's better to just start like apply for H4 here in the US, or is it okay to go to like India and apply for a H4?
Well, if the 60-day grace period covers your trip out, I would not see any problem. That's a no-brainer. You have to go out and get an H-4 visa stamping anyway. But what if you are leaving after the 60 days grace period? I don't think filing an H-4 is required, because ultimately, if you travel while the H-4 petition is pending, you have to apply for a visa anyway, and that petition is deemed to be abandoned. But if you are reluctant about being out of status, which is what happens after 60 days, you should apply for an H-4. It's a waste of money, but you won't be out of status. By the way, being out of status is not a bar from getting a future H-4, H-1, or even a green card, as long as it is not unlawful presence of 180 days or more. So that's a whole another set of discussion points. But the bottom line is, if you leave within 60 days, I don't see the need to apply for an H-4. But if you leave past 60 days, then you have to decide whether you feel more comfortable filing a derivative or a tourist visa petition. And when you leave, that will be all gone and useless anyway, but you will never have been out of status in this country even for one day, which may not be a problem for visas like HL, green cards, etc., but it could be a problem for future student visa or a tourist visa if you ever needed one. Does that help?
Yeah, that helps. So if we apply for an H4 here, that means, and we leave the country, I would need to apply a new petition anyway.
No, you will not need to apply for a new petition. That petition would be deemed to have been abandoned when you leave, but you would have to apply for a visa in a consulate, H-4 visa.
Okay. Got it.
And remember, H-1 and H-4 are different. Just like L-1, L-2 are the same thing. To get an L-2 or an H-4, you don't need an H-4 L-2 approved by the USCIS. Based upon the H-1 or L-1 approval, you can walk into the consulate and obtain an H-4 based upon the proof of relationship. So you do not need that petition filed at the USCIS. You can directly apply at the consulate.
Okay, sounds good.
Okay.
Yep.
What else?
And how long generally does this H-4 process take?
Several months. I cannot tell you how many. Multiple months.
Got it. Okay. And is it possible to transfer from H-4? Say I got my H-4 approved, and it is in process of, I think, stamping from India. Now, will the transfer to H-4 to H-1 possible from India?
So the question is, I am in India.
Mhm.
I have my H-1B approved in my absence, or I'm going to apply for an H-1B while I'm in India. Well, you have to discuss with your lawyers exactly where you are situated. But if you apply for an H-1B while you are outside the US, you will have to get a visa stamping as far as I can recall. Even if you have an existing visa, you should definitely check with the consulate if you need a new visa stamping. Okay, consulates usually will tell you that we want to see a new visa stamping. All right, so can you travel on the approval with the visa of the old company? I'm not quite sure about that. I have to look up the law on this. I remember there was a problem with one of our clients when they tried to do that. It becomes problematic. It is best to check with the consulate if getting a new visa stamp is not an issue and they are actually issuing visas. Otherwise, just post this in one of our community calls. We do one every other Thursday anyway. In fact, we have one tomorrow. You can always post in the community conference calls. I'll double check for you. But can you do it? Yes. Does it become a little bit more involved, more complicated? Yes. It should be double checked, and we will as and when that time arises.
Got it. One basic question, removing H4 from this. So say I didn't get the employment, and from H-1B status, my grace period got over and I go back to India. Now, will I be able to apply from India for an H-1B since there is this validity period?
Absolutely. Once your H-1B has been approved and you were already working on H-1B, you will never be subject to the quota again if you follow the remainder rule. So there are two options. Let's say I worked in the United States on H-1B for 2 years. Then I left. And now I've been outside USA for 3 years and I want to come back. Will I be subject to the lottery? And the answer is that depends. If you are willing to take just the remaining 4 years of H-1, because you already used up 2, you are not subject to the lottery forever and ever and ever. Okay. But if you say, well, I've been outside USA for 1 year, I would rather take my whole 6 years, which you can because it reset the clock. But then you have to go through the lottery. So if you take the remainder option, you do not need to go through the lottery. You can apply anytime. If you take the remainder if you do not take the remainder option, you have to go through the lottery again. Make sense?
Got it. I see. Could you explain a little bit about B1 and B2 option?
Yeah, B1, B2 option is a relatively weak option. There are a couple of articles I've written on my blog about that on immigration.com. You can check those out. But what we do is we explain to the government there was an unexpected layoff and I am looking for a job. I will not start working until I get an approval. I realize that I've got savings to support myself. I will not be working without authorization. Normally, they deny those applications saying, well, B1, B2 is not really a visa for this purpose. It's for rest and recreation, etc. But what happens is, while this is pending, you are not out of status. You are in authorized period of stay.
I see.
It gives you the opportunity to interview and be prepared for another job. And when they apply for your H-1B, you just step outside USA, get a visa, and come back. It gives you the opportunity to stay and interview.
Got it. No matter what the visa status is, we do have to step out from the US and get it stamped and then come back. Is that true?
No, that's not an accurate statement. If you apply within 60 days, you don't have to step out. If you already have an H-4 approval, then you apply for a change of status, you don't have to step out. So that's not an accurate statement. The only time you have to step out is if you are in between applications. If you have filed after 60 days for a change of status and it is not yet approved and you want to convert to H-1B, you'll have to go outside US.
Got it. Okay, I see.
Let me cover one more issue for you. Sometimes people ask us, can I get unemployment insurance? And that depends upon the state law. I think during the 60-day period, you should be able to, depending upon the state law, each state has its own take on it. One of the problems is that when you apply for unemployment, you have to have valid legal status to receive the unemployment under most state laws. So check on your state law whether you can get the unemployment benefits during the 60-day period and after the 60-day period.
I see. Okay. Yeah. And for H4 transfer, what are all the documents generally needed?
That I will not cover. That's too generic. You can look at the form I-539. It tells you what to submit.
Okay.
Just another question. So if say we are in India, we applied for H4 transfer, and then came back to the USA, and we apply for a H1 here and got it approved, we don't actually need to go back to get the H1 stamped, the new H1 stamped.
That is correct. So
Okay.
you got your H4 visa from outside United States. You returned, and she's on H4, and now she wants to apply for an H-1B. She will not have to go out again because she'll be given change of status from H4 to H1. Next time when she travels, she can get an H-1B visa stamp or even use the existing stamp from the old employer.
Got it. But if it's outside the USA, we still need to get the H1 stamped.
That's my concern is I don't remember. There's a little twist in the law there, and I don't remember off the top of my head. Can you still use the old visa stamp if your H-1B is approved while you're outside the United States and you applied while you were outside the United States? I think there's a little twist in the law, but I don't remember exactly what it is.
Okay, sounds good.
I have one more question. So, say I got new employment during the grace period, but then I have to travel to India when the transition is happening. So, so that time, what will be the status that I will be in, and how?
Okay, hang on. That's easier to answer.
Okay.
Double check because the rules for 60 days grace period might be slightly different. I don't remember, but let's remove the 60-day grace period from the picture for a moment. Again, this is something I have to look up. I don't want to say this is the way the law is. But let's say you were in regular H-1B and you applied for an extension or a transfer. It's permissible for you to travel while that is pending. And you can actually return within the life of the previous visa if you have a visa stamp. Does the same rule apply for a 60-day grace period? It might, but you should confirm that before you leave. And if you are not able to confirm that, just post it in our bi-weekly community conference calls. I'll confirm that for you.
I see. Got it. Yeah, these were the questions that I had.
Okay. So for the community, one of the questions that is asked is, what happens to my green card process? And the answer is, unless your I-140 is approved, PERM is approved, I-140 is approved. If you lose your job and I-140 is not approved, you get no benefit of the green card. But if the I-140 is approved, then you keep the priority date. If the I-140 stays approved for 180 days, you also firm up and make concrete your right to extend H-1B through any employer past 6 years. So there are two rights. One is the moment the I-140 is approved, the priority date is yours. In addition, if the I-140 stays approved for 180 days, you also have the right to extend H-1B with any employer. If, on the other hand, PERM is approved, I-140 is not approved, you get nothing. So just remember that. Okay?
Got it.
Anything else I can help you?
No, Rajiv. Like from my side, these were the questions.
Okay, very good. I'll post this. I'll have Monica post this, and you can look it up on our social media. And if you still don't get it, just go ahead and send me an email. All right?
Sure. And thanks for answering all the questions.
Always a pleasure.
Yeah.
Good luck, guys.
Thank you, Rajiv.
All right. Bye-bye.
Bye-bye.